arbitration clause. And we would like to point out why the bank had an intent and interpret the facts given in the case. We would first like to invite this court to look at the letter of credit, page 20. Page 20 of the letter of credit exhibit C3. And it is observed there are 6 required documents to be presented by the seller in order for the bank to honor presentation. 7. The 7th is a statement in the form of annex. It's not a document, it's just the letter which shall be sent by the seller. So we do not consider it as a document. The second, I would like to turn this court's attention to page 15. It's a shipbuilding contract. And the documents which stipulated here, it's 5 documents to be presented. So the ship safety certificate is missing. And our interpretation of this discrepancy is as follows. That the seller presented to the buyer 5 documents, not 6, but 5 documents, which correspond to the requirements of the shipbuilding contract. And after short review of this document, the bank considered himself to be bound by the shipbuilding contract. And in the letter to the buyer, page 29, he says that after a short review, we are planning to honor presentation. So he did not send him that the document, it can be easily counted that there are 5 documents, not 6 documents. It's easy to count. And he sends that he's planning to honor presentation. So he considered that the provisions of the shipbuilding contract were satisfied. So he considered himself bound by the provisions of the shipbuilding contract. And it's the only interpretation possible. Because if we consider otherwise, we cannot understand how the professional player on the financial market could make such an easy counting mistake by accepting 5 documents instead of 6 documents. And therefore, we consider that this was initial intent of the buyer to be bound by the provision of the shipbuilding contract, and it's from the beginning considered itself bound by it. So the intention, the core criteria to be bound by arbitration clause, which is stipulated in New York Convention and in model UNCITRAL law, was satisfied by that. Furthermore, even if this tribunal will not accept the argument of such interpretation, we consider that respondents had themselves said that the clause is ambiguous. And here we ask this court to apply unidroit principle contra preferendum, which means that when there is an ambiguous clause, it shall be interpreted against the party who suggested this clause. And since respondent issues the letter of credit, this provision shall be interpreted against the bank. And therefore, the arbitration clause should have a bound effect upon the bank. If this tribunal...
Isn't that the principle that it should be interpreted against the party which seeks to rely on that clause?
Exactly. And who suggested the clause and seeks to rely on the clause. And it's the respondent who suggested the clause and now relying upon it to state that shipbuilding contract was not incorporated in the arbitration.
But aren't you relying on the clause though to say that it's a valid arbitration agreement?
Indeed, but we were not the party who suggested the clause. It only concerns the party who suggested the clause.
Neither did we.
If this court has no further questions,
can I clarify your position one more time? So you are saying the arbitration clause was incorporated by reference, right?
Exactly.
And is it your position that they became a party of the arbitration clause? How? Can you one more time? Because I'm trying to understand why they are a party to the arbitration clause. I understand by reference point.
If we leave this interpretation aside and refer only to interpretation by reference, it can be done two ways. Either exact reference to the arbitration clause or the general reference to the document which contains this arbitration clause. And both ways were recognized to be sufficient for the parties to be bound by the arbitration clause in that separated document. And there was one requirement which all tribunals, it was 11 cases of the ICC tribunal, where the tribunal stated that the party would be bound by the arbitration clause in the general reference only when the party knew or should have known the content of that document. Claimant does not possess any facts whether the bank read or did not read the content of the shipbuilding contract. However, we submit that even if we consider the fact that the bank included the reference to the shipbuilding contract even without reading it, so it is a gross negligence from the side of the bank and it is a risk of application of the shipbuilding provision. It's now lying on the respondent. Therefore, we submit that since the bank should have known the provisions of the shipbuilding contract while inserted the reference about it, it bound itself by the arbitration clause.
Two more questions.
Please.
First one is how do you comment on this provision of UCP 600, which says that the letter of credit is separate from the contract? This is the first question. And this, well, probably you address this first one because the second question goes back to the suspension. And,
we consider that in this regard, bank acts unfairly and its behavior is contradictory. So the bank first cite UCP 600, Article 4 about the autonomic character of the letter of credit, and at the same time it violates Article 4 regarding Article 4 which state that an issuing bank should discourage any attempt by the applicant to include as an integral part of the credit copies of the underlying contract. So it's first violated and then invoked it to justify. And it is a clear violation of general principle of law, which sounds as nullus commodum capere de suo injuria propria. That means that no one can benefit from its own wrong. And therefore, we submit that the bank cannot justify its action regarding the inclusion of reference by referring to the autonomic character of the letter of credit.
May I also amend the position of my product? If we apply to the Article 1 of UCP, it states that these rules, UCP 600, are applicable for all the parties, except for the situations where otherwise is not expressed in the text of the letter of credit. And we state that this reference to the letter of credit is the mere situation where the parties themselves excluded some parts of independence, nature of the letter of credit with regard to their transaction.
the second question is going back to the suspension point. Could you please comment, it's page 28 of the materials, Act of Acceptance. So, as I understand, your position is that it doesn't actually matter whether the act was fraudulent or not, because we are looking at the letter of credit and
Strict documentary compliance.
yes, strict documentary compliance. From this point of view, we see that the signature of Mr. Avyazov, on its face, it says Konstantin Aivazovsky. So my question is whether this on its face says that the documentary requirements has not been made.
I understand your concern, and the claimants submit that the bank should not pay attention to what exactly the signature is, whether it's 70% not like the signature which on the bank card, or 50% not like the signature on the bank card. Because what the bank should do is to check strict documentary compliance. It is the first argument. So there is a stamp and the signature that sits for the bank. And the second argument is that the bank could not use the credit card of Mr. Aivazov because it was not listed in the documents to check the signature. And the third argument regarding this is that the bank could not send to the buyer all documents stating that we plan to we plan to honor the letter of credit and enclose all documents, because the bank could only send such emails when he himself finds that there is a discrepancies, and to show those discrepancies to the applicant, to show those discrepancies to the buyer, and not the way he did it, because he was actually planning to issue to honor the letter of credit after he reviewed, and so the signature and the stamp.
Thank you. So we will now have to rebut.
One small question. Again, to the priority of the contract and the letter of credit. Just shortly summarize, why do you think that one of the lists of documents that should be presented supersede another? Why do you think that seventh document in letter of credit should not be taken into consideration, and the list which mentions the contract should prevail?
May my partner address this? It's material part.
Yes, regarding this question, we state the following. The letter of credit, by its nature, is a contractual obligation. And one of the core principles to which my colleague has already referred is contra-preferential rule. So, as our opponents has already admitted, there is an ambiguity with regard to provisions of paragraph 10 of the letter of credit. And following the contra-preferential rule, this ambiguity must, after reasonable interpretation, must be interpreted against the party that supplies the term. So our interpretation is that this provision creates a hierarchy in between the letter of credit and the shipbuilding contract, in which the letter prevails, and which means that the list of documents in the letter of credit prevails the list of documents, list of documents in the shipbuilding contract, prevails the list of documents in the letter of credit. And also get another argument in that regard. We state that even if our opponents will apply to the principle of independence of the letter of credit, which is expressed in Article 4A of UCP rules, their major parts. If we look at UCP principles at all, we see that it's a set of standard terms. The UCP rules are used on constant basis between different parties in different commercial relations. And as far as to the provision paragraph 10, which refers the as to the provisions of the letter of credit, which refers the letter of credit to the shipbuilding contract, is a specific term. And in case if this provision of UCP, which requires to have no reference in the letter of credit to the shipbuilding contract, contradicts this specific provision in the letter of credit, which actually refers the letter of credit to the shipbuilding contract. The provisions of paragraph 10 prevail, and that is why we consider that the list of the documents in the shipbuilding contract prevails.
I think the tribunal has no further questions, in which case we'll then proceed to the vote.
You can go to the back. Okay, first of all, I want to refer to the issue of the tenant that they made the connection of our criteria with the Article 41 of the okay. We want to state that in this article there is stipulated that if some facts, some actions is not regulated by the ICC rules, it is the ICC arbitrators need to take in account, so to be led by the principles of regulated by the common sense to fulfill, to make the execution of the decision. Of course, we don't opposite this fact, and we need to state that, for example, requirements for suspending the proceedings that we already have stipulated doesn't preclude this purpose to fulfill the decision, to execute the decision. Of course, we just want to suspend the proceeding, then to take the decision and to fulfill, to execute it. We don't. These requirements of the International Law Commission, that's stipulated in recommendations, they are not in the contradiction with this article, and they are not make the penal arbitrators not to be led by these principles, not to fulfill this article, not to be in compliance with it. This is my first argument. The second, I want to go to the active acceptance, that the claimant said that it is not important for our proceeding. Of course, it is important because we need to state. For example, let's just imagine a situation when, for example, there are just one problem of making the payment. For example, there is no problem with safety certificate, it's just a problem with active acceptance. Of course, we're the bank and we need to look at the document like on the face. But you know, for example, if some person comes to the bank and just make some documents with the name active acceptance, if we don't need to pay attention to the seal, we don't need to pay attention to the signature, we just take this, maybe it will be just with the name. It's like just one page with the name, and there is nothing, we need to take this document to make a payment. Of course, for example, there is a right in Article 16 of UCP 600 that we can, when we have some doubts in the document, we can refer to the applicant. It will be, yes.
When an issuing bank determines that the presentation does not comply, it may, in its sole judgment, approach the application for a waiver of the discrepancies. That's what we did. We were cooperating with our buyer to avoid these discrepancies. And there, so we made additional work. We wanted to proceed the payment, but we failed to do that. So, and by saying that we were planning, we were just planning in the letter that the claimant refers to. But we were just planning. We didn't say that the analysis, the review of the documents had already been conducted. The only evidence that we say where the analysis had been conducted is the other letter when we say we cannot pay.
And also the last argument that I want to refer, it's the fact that about the reference in the letter of credit. For example, if we are conducted by the international trade law, by the best principles of the international trade law, we want also to pay attention to some case practice. For example, there is a case between Gronsted versus Reed, where is the court stated, the ICC court stated, that parties are considered a related arbitration clause only if they clearly and definitely express their consent to the obligation in the letter of credit clause. And we need to say that we already have done it and we don't want to spend the time that there wasn't clearly and definitely expression, neither implied, neither direct consent. So.
Just one final question, on the suspension of these proceedings, which I understand the main argument to be that there is a risk of some inconsistency in the decisions.
Inconsistency is
in the two arbitrations.
Yes.
But do you accept that this tribunal is not in any way bound by the outcome of the other proceedings?
Of course.
In which case, isn't there a risk in any event of inconsistency?
We don't see the risk in the bounding, that the decision of the other parallel proceedings will be bound for the current proceedings. But the fact that will be proved there and the award that will be rendered there may have a major importance. And when we will have our, for example, decision from these current proceedings, we can go to the contradictory between these and the other. And so I think it will be not in compliance with the purposes of the ICC arbitration, and also not in compliance with the ICC rules.
I'm not sure if I've caught the answer to the question, but is there a risk in any event of any inconsistency between the two?
Risk if, for example, the decision of the other parallel proceeding will be other or will be different. But it's contradictory. It will be like one, for example, decision will grant some rights to one party, as we already said, and for example, our president will grant the same right but to the other party. So which decision we need to fulfill? And if we, for example, to fulfill one decision and then we fulfill another, it will be contradictory. We need to pay and then to pay again, to pay back to the exchange.
So it might change the facts on the ground, in other words. I understand.
Claimant would like to rebuttal of the respondent, and the respondent cited Article 41 of ICC case, of ICC rules, and said that the requirement they transferred from the International Law Commission do not contradict Article 44, and we do not contest it. The only thing that the claimant contested in its presentation were the interpretation of the facts of the case and not the requirement itself. And we did not agree with the respondent on the interpretation of the subject of both proceedings. And therefore, we submit that it is ungrounded to say that it will lead to contradictory words. Second issue raised by the respondent was that according to Article 16 of UCP, the letter which dated the 7th of March and concerned the compliant, and which concerned that the bank made a short review of the received documents and is planning to on a presentation, cannot be regarded, as respondent said, cannot be regarded as a try to negotiate with its client the discrepancies which were found in the document, because we see that nothing about discrepancies is said in this letter. It just said that after a short review we are planned to honor presentation. So therefore we submit that the bank cannot apply Article 16 of UCP as a waiver. And the last issue, which was said by the respondent, regarding the related arbitration, and it's again the repetition of the suspension issue, and therefore we will not comment.
No. Have you then, so have you used all your time now on this, or do you intend
Yes,
to-
1 minute.
Okay.
Yeah.
So there's not going to be a transfer of time?
No.
yet? Okay. And everyone's agreed to it. Very good. Okay.
Not proceed with this.
Please.
Okay. I will present a claim with regard to the claimant's arguments to the substantive part. And in my presentation, I will cover 4 issues that are essential to be resolved by the present computing tribunal in the present dispute. The first issue concerns the question whether the respondent at all has any right to apply to discrepancies that he finds to be apparent in the document. The second issue concerns, which is alternative to the first issue, concerns even if the respondent has such a right, whether the Acceptance Act is compliant. The third issue concerns the National Passenger-Ship Safety Certificate and the necessity of its presentation by the claimant. And finally, the fourth issue, I will speak on whether the claimant at all made a compliant presentation and whether the respondent had any grounds to refuse the presentation. So proceeding, but before I proceed with this issue, I would like to briefly identify which law the claimant finds to be applicable to the present dispute. As to the letter of credit, we find that UCP Uniform Customs of Reference as specification number 600 is applicable due to direct reference to letter of credit to this document. Also, we may apply to International Standard Banking Practice on examination of documents, revision 2013, publication ICC number 745. As to the both shipbuilding contract and the letter of credit, we find that general principles of Lex Mercatoria are applicable, and in particular we may apply to UNDRAC Convention revision 2010. As far, with regard to the shipbuilding contract, we used this right as far as the parties established that the best principles of international trade law are applicable, and we can see it in the shipbuilding contract itself. And whenever, as established in the preamble of the UNDRA principles, whenever the parties make such a reference, they may apply to UNDRA principles. And with regard to the letter of credit, we state that the letter of credit by its nature is a contractual obligation. And with regard to contractual obligations, as it is also established in the preamble of the UNDRA principles, whenever the parties have chosen the law applicable to their contract, UNDRA principles are applicable. So now I will proceed with the first issue. So, did the bank has any right to apply to discrepancies with the letter of credit? We'd like to put the tribunal's attention to the notification that the respondent sent to the claimant with regard to his refusal to pay under the letter of credit. In the UCP 600, there are certain requirements applicable to the notification. As it comes from the Article 16, in such a notification, there must be covered three main issues. Firstly, it's the mere refusal of the bank to refuse the presentation. We see it in the letter to the claimant. The second issue that must be covered by such a notification is what are the discrepancies actually found in the presentation. And we also see this issue covered in the notification. However, there is also a third issue. The bank must establish what must be done with the documents and to which party actually the documents must be submitted or they must be held by the bank. And with that regard, we have no reference in the letter made to the claimant, which is the notification made by the bank, to which would cover this issue. And if we apply to the article, to the paragraph F of the Article 16, if an Asian bank or fails to act in accordance with the provisions of this article, it shall be precluded from claiming that the documents do not constitute a compliant presentation. So we firstly address the tribunal's attention to the fact that the respondent has no right to apply to any discrepancies. However, proceeding with the second issue, if by any reason the arbitral tribunal finds that the claimant has such a right, we would like to address the issue whether the Acceptance Act is compliant. We state that the Acceptance Act follows all the requirements of compliant presentation. And we've got three arguments with that regard. Our first argument is that the letter of credit is compliant due to the mere fact of that there is a corporate seal on it. If we look at provisions of Article 3 of UCP 600, a document may be signed by handwriting, facsimile signature, perforated signature, stamp, symbol, or any other mechanical electronic method of authentication. If we look at the Acceptance Act, which is Exhibit C8 at the page 28 of the case materials, we see that there are both corporate seals, and we state that this requirement of the Article 3 of UCP is satisfied, even though, even if there were no signatures, we may apply to this article to justify representation. Our second argument is that the bank has no right to apply to the credit card of the buyer's president in order to justify his refusal to pay. As it comes from the UCP requirements, the bank has to examine on the basis of documents alone whether they, on their face, constitute compliant presentation. So if we look at the Acceptance Act without reference to any other documents, we see that it is totally compliant with that requirement. However, there is another requirement of UCP 600, which states that the data in the document is provided by Article 14D of UCP 600, and states the data in a document, when read in the context with the credit, the document itself and international standard banking practice need not to be identical to, but must not conflict with the data in that document, other stipulated documents, or credit. We state that with regard to this requirement of UCP 600, the respondent had no right to apply to the document which was not stipulated to the presented documents. It means to the credit card to the buyer. And our third argument is that examination of authenticity, genuineness, a legal power, or falsification of any document is out of the bank's scope of examination of documents. And as it comes from the Article 34 of UCP